XRP Ripple News and Price Prediction, July 2nd. In today's XRP Ripple News and Price Prediction. Court says the SEC abusing its power. Alright, let's get started. The Securities and Exchange Commission's SEC bombshell lawsuit against fintech startup Ripple Labs is now a cause célèbre in the cryptocurrency community. However, a mimicable court in the Northeast state this a clear indication that the SEC is abusing its power by having a large implication about regulatory overreach against innovation is provoking principled debates in some of the country's most influential policy circles. The Federalist Society's Regulatory Transparency Program, RTP, an organization dedicated to fostering discussion and understanding of regulation. In December, the SEC sued Ripple and two of its top executives for 7 years of distributions of the cryptocurrency XRP, which the agency labeled as illegal unregistered securities trades. Ripple offers a global payments platform for some 2 million users worldwide for the XRP token and its fully decentralized ledger. The company ferociously disputes the allegations by making clear that the regulatory agency allowed billions of XRP tokens to circulate freely on global cryptocurrency exchanges for 7 years without making such a determination, despite being asked in public and in private for that specific clarity for years. The SEC also alleges that XRP's only utility is to be an investment contract in Ripple and that all XRP holders depend on Ripple's actions to obtain a return on their holdings. The suit seeks to enjoin the registration of XRP as a security and preclude Ripple's executives from participation in the market. The event explored whether and to what degree the SEC may violate the legal and constitutional principles of fair notice, due process, and rule of law. Many saw the SEC's timing suspicious. The sudden thud dropped on the last day of the prior SEC chairman's term, after XPR had been in circulation for so long. The event was moderated by Committee for Justice President Kurt Levy, noted conservative attorney and scientist. Following is a summary of perspectives of the panelists. With the SEC's action, the value of XRP has plummeted. Some 50 exchanges delisted or suspended trading XRP, and the currency lost 75% of its value. XPR holders, who were driven to panic selling after the SEC's action, are outraged. John Deaton of the Deaton Law Firm and the website Crypto Law is leading a challenge to the case, separately from Ripple. He filed a writ of mandamus to challenge what he called the egregious, inappropriate action of the SEC and subsequently a motion to intervene in the SEC's case in the Southern District of New York on behalf of more than 18,000 XRP holders. Many of these individuals, app developers, organizations, businesses, and others swear that they had never heard of Ripple prior to the case and never saw XRP as an investment contract in any company. Prior to the SEC's action, XRP was openly traded on more than 200 currency exchanges. Many countries are developing digital currencies, some of which may utilize the XRP ledger. The World Economic Forum noted XRP as the most relevant cryptocurrency for central banks. Financial regulatory authorities in Japan, Singapore, the UK, Switzerland, and the UAE have already declared that XPR is a currency, not a security. XPR Arcade notes some 360 different kinds of organizations which use the currency as a means of exchange, including wallets, marketplaces, money transfers, banks, and more than 150 consumer apps. Some firms pay international employees through XRP, and consumers use it to buy groceries and to subscribe digitally to Time magazine. Deaton detailed a series of actions, events, and conflicts to diminish the SEC's case. In 2015, the Ripple and Department of Justice reached a settlement that XRP is a convertible digital currency, and that Ripple is a transmitter of XRP registered with the Department of Treasury's Financial Crimes Enforcement Network, FinCEN. Ripple agreed to comply with U.S. currency laws, not securities laws. In 2017, when the SEC brought cases against initial coin offerings, it did not include Ripple. In 2019, the SEC accepted Ripple's $30 million equity investment in MoneyGram to extend money transfer via blockchain. Similarly, Ripple informed the SEC to list XRP on Coinbase, the cryptocurrency exchange platform. The SEC said nothing in response to these events, which would indicate that XRP is not a currency and that Ripple was not in compliance. Former SEC Chair Joseph Grunfest implored the agency to not proceed with the case, warning that it would cause multi-billion-dollar losses to innocent third parties. Deaton also detailed a series of troubling, unseemly conflicts of interests with prior SEC leaders who favored other tokens with much more solid investment contract arguments while bringing the hammer down on Ripple. Carol Goforth of University of Arkansas School of Law weighed in on the key question of the Howey test, whether a transaction qualifies as an investment contract, defined by investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. For the SEC's purposes, such a determination deems the asset a security which subsequently can be subject to disclosure and registration requirements under the Securities Act of 1933 and the Securities Exchange Act of 1934. The term originates from the Supreme Court case SEC versus W.J. Howey Company, whose defendant was an individual with citrus groves in Florida who kept a portion for his own use while selling real estate contracts to finance future growth. Goforth argued that the SEC is in the right with its determination but displayed untoward behavior and timing against Ripple. Goforth observes that the value of XRP is derived, at least in part, by the efforts of Ripple. However, she is appalled by the SEC's treatment, noting that it waited years to issue the ruling. A similar fate could befall Bitcoin and Ethereum, which are by no means safe from being redefined by regulators. The challenge for Bitcoin, however, is that there is no single party to which the SEC could bring a suit. Or, perhaps, because the SEC would have to sue China, which has controlled the hash rate of Bitcoin for years. She also observed that XRP has many uses which the SEC's action has not necessarily precluded. People still use it as a form of exchange. Moreover, that the DOJ, FinCEN settlement does not exonerate Ripple of other charges. It is notable that new SEC Chair Gary Gensler has not revoked the case. However, his preference is for Congress to clarify how the SEC should proceed. This admission confirms the view that Gensler's predecessor, Jay Clayton, acted capriciously. Goforth concludes that the regulations are a mixed bag which fall unfairly Ripple. There should be room for reasonable exemptions, and that it will likely take an act of Congress to fix. John Berlau, Senior Fellow at the Competitive Enterprise Institute. This traced the history of financial innovation in his best-selling book George Washington, Entrepreneur: How Our Founding Fathers' Private Business Pursuits Changed America and the World, noting how the first president used tobacco warehouse receipts for money. That's what's been happening this week in the world of XRP Ripple news and price prediction. If you haven't subscribed yet, make sure you click the subscribe button at the bottom right and subscribe to All Investments right now, so that next week you'll get the inside scoop on the latest developments to keep you and your business on the leading edge of XRP Ripple news and price prediction. If you enjoyed this edition of XRP Ripple news and price prediction, leave a comment and please hit the like or share button, we'd really appreciate it. Are you still watching and want more? Check out last week's XRP Ripple news and price prediction by checking out our XRP playlist.